Hi, I'm Howie Slumka with My ATL Law, and many clients want to know whether all of their debts get discharged in bankruptcy. It's a great question, and fortunately the answer is most of your debts will get discharged in bankruptcy, and a good law firm and a good lawyer will help distinguish the ones that are dischargeable and the ones that are not. To explain which ones are not dischargeable, I like to go back to the United States Supreme Court. It held in a case that the bankruptcy law is there to protect the honest but unfortunate debtor. That means if you have simply run out of money and you cannot pay your debts, as long as you haven't filed bankruptcy in the last 8 years, then most of those debts are going to be discharged and you'll get a fresh start. So what does it mean? Does that mean that if I'm dishonest, somehow my debts are non-dischargeable? And the answer in the statute is more or less yes. Section 523 of the Bankruptcy Code lists a number of types of debts that are non-dischargeable. The most important ones of these have nothing to do with honesty or dishonesty. If you owe money to a spouse through a dependent support obligation, if you owe alimony, child support, that is a non-dischargeable debt. Bankruptcy will not help discharge that debt. The next most common question with regard to dischargeability are student loans. And student loans are not dischargeable in bankruptcy. Many people find on the internet that yes, they are. There is a very, very small exception, and it's a very narrow loophole for those for whom student debts are non-dischargeable because of a hardship discharge. It is a real narrow exemption. And I like my clients to know that, because in most cases your student loans are not going to be discharged by bankruptcy. Your secured loans are not discharged. If you don't want to pay for your house or your car anymore, you don't have to. You can walk away from the debt. But you cannot walk away from the loan and keep living there. You cannot walk away from your car loan, stop paying it, and keep driving it. But bankruptcy can treat those secured loans in a very special way. And come see us and we'll explain. In many cases, people who have been paying $400 or $500 or $600 a month from their car can keep their car but pay half that much every month. Finally, I do want to talk about the fraud exceptions. There are a number of things that people do that involve intentional acts. Some of those might be driving while intoxicated. If you get in a car accident and you owe somebody $1 million, that debt will not be dischargeable in bankruptcy. If you've committed an act of fraud, or even if you've been held to have committed an act of fraud, those are two very different things, especially since some clients suffer what we call default judgments. Somebody sues you, they say that you intentionally deceived them, you owe them $100,000, that will not be dischargeable in bankruptcy. And then some other things that deal with possible violations of security laws or fraud in the fiduciary capacity, things like that would not be dischargeable. So in our initial consultation, we'll be able to take a look at the debts that you owe and determine which ones are dischargeable and not dischargeable. And the final point I want to make is tax debts. The good news is that tax debts can be dischargeable, but not new or recent tax debts. We usually have to wait about 3 years before your unpaid tax debts can be discharged. And finally, you must be a tax filer. If you have never filed your taxes, no matter how much you owe or no matter how old they are, those tax debts would not be dischargeable in bankruptcy.